Number 2, matter of mental hygiene legal services versus Daniels. Thank you. Counsel?
May I reserve 2 minutes for rebuttal, please?
You may.
May it please the Court. For 2 independent reasons, the lower courts should have dismissed this mandamus proceeding. First, MHLS lacks standing. Second, because Article 9's definition of record does not include a patient's clinical chart, their statutory...
Counsel, how do they lack standing if 9.31b specifically identifies them as a recipient
They're only receiving...
of the record, right? I mean, the duty and obligation is to the court to get the record, the copy, and to MHLS. They're specifically identified in the statute as, if you will, a beneficiary of the obligation.
They're receiving it as the potential agent for the client. It's analogous to, for example, the provision in CPLR 2103B that says that once a party is represented by counsel...
Well, it doesn't say that because, of course, the patient may have someone else representing them, and it doesn't say that. Otherwise, it would have said, as, of course, the statute does in other sections, the patient and their legal representative. But it does only identify the court and MHLS.
As a practical matter, MHLS is going to be representing a very large number of patients, and they're receiving the record. And as I will address, record does not include the clinical chart in any event, but they receive it in their role as an agent of the client. One would not say, for example, in a criminal case...
Well, there could be more than one beneficiary, right?
There can be, but not in this case, because the only person whose rights are at stake in a retention proceeding is the client.
If MHLS didn't represent the patient, would there be any potential injury here?
There would not. There's no injury in any event because the legislature designed a particular statutory scheme in which MHLS, for the benefit of patients, has a better form of access to documents than advanced disclosure.
Let me ask you about that. Suppose, hypothetically, you denied MHLS access to any records, right, in contravention of the statute. Would they have standing?
They would not have standing. They would, in a particular patient's case, come in and say, we can't go forward.
But if you block them from access categorically, they wouldn't have standing under the statute.
The right would always belong to the patient. They could, of course, in the patient's case, say...
Isn't this different because isn't this more like a state authority or a municipality where the specific right of the party is set in the statute as opposed to... I understand your argument, the strength of your argument, as in responding to an organizational plaintiff. I think that's a good argument. What I don't understand your argument on standing for is as it applies to a designated government agency or an arm of the government saying this record must be provided to them. The record wasn't provided, therefore, at least that's arguable for our purposes, therefore they have standing to go and say we want this record. In this particular form, and the question of what you get in is another question, what form you get in it. But it seems to me that the analogy to be drawn is between other types of government, arms of government, not-for-profit corporation, that have standing to go into court to assert particular rights and responsibilities that they have by statute. So why doesn't MHLS have the same kind of rights here, since they're designated, to follow up on Judge Rivera's question?
The MHLS is an organization created for a very specific purpose, which is to represent...
As the throughway authority is, but they can go into court and argue to assert their particular rights. They have standing to do that.
But in any event, there is no injury in this case. Because
well, that's a separate question. Let's just stay with whether or not this entity can go into court, because that's the question that interests me. I want you to stay on that. Why can't they do that? Why doesn't that analogy hold true?
So I'm not aware of a case in which this court has said that an entity that is representing someone else's interests has standing based on a denial of that interest. The injury, any injury would be to the client.
No, that's not what I'm saying. I don't want to beat this to death, but what I'm saying is that this agency is told that they have a particular right to particular information by statute, by the state legislature. And you're saying that they don't have standing to assert a statutorily given right in court. And not because of the injury in fact, but by the nature of who they are. And I'm saying by the nature of who they are, they got a right to go to court. Whether they're not going to be successful is a different question. But why wouldn't they have a right to go to court?
Your Honor, my answer is that the right belongs to the client, and they are only given, there's only a requirement that
So why
MHLS
doesn't the legislation say then that, as has been pointed out, the client and their legal representative?
Because as a practical matter, MHLS is going to be the
Yeah,
attorney.
but they all aren't represented. I've done a lot of these things. They aren't all represented by MHLS. Yes, the vast majority are, but we both know they all aren't. So that's not an adequate answer.
But when we talk about standing, so the fact that the statute refers to MHLS, and maybe I'm mistaken here, but my understanding is that means that MHLS is in the zone of interests sought to be protected by the statute. But there are other requirements that have to be satisfied before they get the right to come into court, one of which is that they have to show particularized injury.
That is correct. And there is no injury here because the legislature made a determination that the best way to ensure full access to the clinical chart is to give MHLS 24-hour access.
Well,
Now,
no, it said two things. It said that first, but then it has another provision right after the sentence you're referring to that says that the mental hygiene legal service may require from the officers or employees, and it continues. I mean, your answer makes that second sentence superfluous, doesn't it?
well, first of all, that statute is not the one under which the petitioner is seeking mandamus relief today. But second of all, that is simply a right to go in and get a copy. It does not involve the statute that is before the court today, which is the contents of the record of a patient as defined in Article 9 that has to be delivered to MHLS 5 days in advance of a hearing. These are two different sets of documents. Clinical record is not part of the Article 9 record of a patient.
But why is there not an injury that they have to, as the appellate division majority pointed out, expend resources where the statute appears to place the burden not on MHLS, but on the facility? Why is that not a sufficient injury?
Putting aside for a moment that the record doesn't include the clinical chart anyway, there is not an injury
No,
because
but that's a question of the merits. We're
Correct,
just
and
on
that's
the standing issue. Don't conflate the two now.
No, that's why I said putting it aside for one moment.
Okay.
The MHLS can, in any individual case, obtain their fees. We pointed that out in our opening brief, and they did not even address that in their respondent's brief. Now, I do want to turn...
But that's post hoc. That's not dealing with the standing question, which is the diversion of resources, not just getting money back. It's diversion of resources to do something that the statute clearly does not put on their shoulders.
The statutory scheme taken as a whole does place it upon them to use their 24-hour access to gain access to the clinical chart. And I do want to move to the merits. The definition of a record for purposes of Article 9, as defined in 9.01, is the admission, transfer, or retention papers and orders and accompanying data required by this article and the regulations of the commissioner. Those are akin to the pleadings in a civil case. And the section under which MHLS is seeking mandamus only requires those documents that are key to the initiation of an Article 9 retention hearing. The legislature gave OMH the option to, through regulation, if it found it necessary to do so, define additional accompanying data that would be included as a part of those materials. OMH has not found it necessary to do so at this point.
I understand your argument to be that the only regulations that would be relevant would be a regulation that either specifically says, pursuant to the authority recognized in the other section, we now are choosing the following documents to be required to be provided, correct? Or something that says accompanying data is defined as.
Yes, at a minimum.
Excuse me.
Sorry.
But the fact that they define a patient's record in a particular way somehow does not fit this final part of the statute?
So the term that is defined in Article 33, which is what the statute refers to, is clinical record. And that provision is used in sections of the statute that deal with confidentiality and rights of access, not with any sort of disclosure requirements. And what OMH did not and could not have done by regulation is actually swap out the definition of record of a patient that already exists by statute in Article 9 and just replace it with a different definition of
Well, see,
regular.
there's where I had a little bit of difficulty with your argument. So the statute says, record of a patient shall consist of, and then it says admission, transfer, retention papers, and orders. You've already taken, set forth your position on that. Then it says, an accompanying data required by this article, and I assume there's nowhere else in the article that it makes any reference to what might be the accompanying data.
No,
correct?
there is.
Well, let me finish it. Okay, you can correct me. And the regulations of the commissioner. So it is already the legislature that is authorizing the commissioner to identify what would be part of a patient's record.
Right. And OMH has not exercised that option. I do want to address the other
Well,
part.
how is that when they've defined a patient's record to include the clinical record?
So that regulation does not apply to Article 9. It applies.
Why not?
It is not a regulation that ever refers to Article 9 or to retention proceedings.
But it's
That
a general mental hygiene regulation. It's a definition section. You mean for each of them, they would have to say this is applying to the following articles?
It is there to define the term where it doesn't already have a statutory definition. In Article 9, there already is a statutory definition, and it's not the same term. It's record of a patient is the term that is used in Article 9. And I do want to address the other part.
So you think that's different from patient record?
Because the point is that Article 9's
Ability and
own
efficiency of saying patient record, you think is different from record of patient?
the principal term that is used throughout Article 33 is clinical record. There is also a reference to patient record, but OMH could not have simply superseded the definition of record of a patient in Article 9 by adopting a regulation that refers to
No, I agree with you, but my point is that record is defined with a list of things and then says, whatever the commissioner identifies in the regulations. And then the regulation, tracking back to that, says a patient record means the following.
Right, but except that that regulation doesn't apply to Article 9. And I do want to address the other part of what you said.
That's the part that I think some of us are struggling with.
It doesn't apply to Article 9 because it does not refer to Article 9. It never mentions retention proceedings. It deals with entirely different concerns such as confidentiality requirements.
Quality assurance of programming.
Quality assurance, correct.
Operating certificates, things of that nature,
That's
correct?
right. And it would have actually been beyond OMH's power to use a regulation to take that definition from Article 3 and just put it in the place of Article 9. It would be over-inclusive and under-inclusive because the documents...
It's not a replacement. The other things that the legislature has identified, of course, are the record. It simply, as the legislature has said, and whatever else the commissioner identifies. You're now filling in that blank with this. The commissioner certainly, if they disagreed, could have written something else, but this is a definitional provision. It applies throughout. There's no limitation in the definitional provision.
What they would have defined would have been the term accompanying data. I do quickly, if I may, want to address what you said before about there not being anything else in Article 9 referring to accompanying.
Yes,
there is. It's the physician certificates. The statute specifically says that the way you initiate an Article 9 proceeding is that the certificate, you send an application, it's the certificates of 2 examining physicians accompanied, it uses the word accompanied, by an application for the admission of such person. Those are the ones required by this article referred to in 9.01. And the remainder, the section required by the commissioner, is it gives the commissioner the option to require additional accompanying data. And that is the term that OMH would have defined. It could not have done what MHLI suggests because that would actually take documents that are already mentioned in records, such as the physician certificates, and it would be under-inclusive by omitting those. It would be over-inclusive because it would include voluminous clinical records that have never been part of the Article 9 record.
Facilities have turned over these documents, though, as part of these hearings, have they not?
There are some facilities in which there has been as a courtesy, something has been turned over, but there has never been a...
So it would not be accurate to say that the commissioner has determined that this is not part of the record.
Well, it is not turned over as a part of the record. It is turned over as a courtesy to MHLS counsel. It is affirmatively not part of the record.
Let's say, because having presided as Justice Fahey, and I don't know about Judge Stein, but literally, you walk in with these evidence carts, and they're full of binders that are yay high, with lots of records of what's going on every day. You know, the patient, spit at so-and-so, the patient kicked so-and-so, all of this stuff, right? It's voluminous. From a practical point of view, doesn't it make sense to turn over what you're going to offer to the judge ahead of time so that you're not all sitting there with the 30 cases on the calendar? I mean, and yes, you're saying it's a courtesy when they do that, but why couldn't that be what the legislature meant when it said give the record?
Well, a couple of points, Your Honor. First of all, it's important to remember that the only term that is before the court today on this mandamus proceeding is the definition of record of a patient in 9.01. So even if the problem that you're describing is a problem, the solution that MHLS is seeking here is not the solution, because that statute deals with a different concern. It deals with giving the court and the attorney it's akin to service of pleadings in a civil case, as I said before. Secondly, the right to any.
So the solution to the problem then is a legislative one, is what you're saying.
The legislature devised a different solution, which is unlimited access. And I also wanted to say that the.
May I ask, when just to clarify, when the lawyer comes in with the binders, or binder if there's only one, do they make reference to what's in the binder? Yes, correct? But they don't turn over copies? They're not admitted? They take this binder back?
The way that the process works, because everyone involved is in the same physical building. The patient is on the ward, the binder, which is the up-to-date
BPC,
record, is on the
yeah,
ward.
okay.
It is wheeled in, as your colleague said, on a cart, and available there. It's available to counsel, it's available to the court, it's available to witnesses. MHLS could, at the end of, before the hearing, after the hearing, take what's in the cart, photocopy it. It's all available to them at 24 hours a day. That is the system that the legislature intended. Now, the alternative.
So if that's
what does the court consider? Because let's just assume, and I know this is rare, that the court doesn't want to give a decision from the bench, wants to reserve decision. And according to what's been presented to us, that entire record on that cart stays within the hospital. It does not go back with the judge to the judge's chambers for consideration. So what I am having trouble understanding is how does the court and MHLS, which are the two entities described in the statute, how do they know what it is that the court is actually to consider in rendering its decision? And do they both have copies of the same thing? How do they know that?
Well, it's there physically on the cart, so it's not as though a copy is being made for the judge and not for MHLS. There's not a copy being made. The expert witness is going to come in and testify, and both OMH counsel, MHLS counsel, and the presiding judge can ask the witness, what are the documents that you relied on? Are there any new developments? And the legislature determined that it had to be done this way because these are short, intensive hospitalizations in which people may be in for a very short amount of time, and therefore the change in the person's condition, either for better or for worse, is going to continue to change right up until the moment of the hearing. And that is why the legislature determined that constant access.
The problem is that MHLS, or not MHLS, I'm sorry, OMH or MRDD is marking this entire thing as evidence, and I don't know if it's being received in evidence, but I mean that seems to be the nub of the problem, rather than receiving in evidence those items that are being referred to and relied upon and considered. So that's.
Counsel, one last question for you. If we were to find standing here and get to the merits, do we need to defer to the agency's interpretation of record?
The court should defer because this involves the procedures used at OMH-run facilities. And furthermore, even if there is no deference granted, this is also a mandamus proceeding, which is why it's not sufficient for MHLS to show that perhaps the regulation they're relying on applies in Article 9. Our position is that OMH affirmatively represents to the court that it did not adopt the regulation.
Under your theory, there is no description by the agency of the accompanying data. There is no regulation that's been actually published that
OMH has not exercised.
indicates OMH's position, under your theory.
OMH has
So what's
not
the
exercised
difference?
its option to
Where's the
define
difference?
additional or accompanying data.
How could there be any difference? It's not, you haven't spoken on it.
Because
Under your theory.
first of all, it's long-standing agency practice that until the recent Gary F. case, out of which this case grew, no one had ever suggested that the regulation MHLS is relying on applied in Article 9. And secondly, because
Yeah, but the practice has also been to turn it over, apparently.
there have been cases where it's been turned over as a courtesy, but not as a part of
Let
the
me ask
9
you, I'm going to ask them too, it's the last question, 'cause I know you have the red light. BPC, of course, the center at issue here, apparently doesn't have electronically preserved records, and that seems to really be a great deal of the problem. Are they unique? Are there many other of these facilities that function in the same way, where everything's paper-bound in a volume?
I don't know the answer to that question. I don't know how many hospitals use a paper system, electronic system, but.
Thank you, counsel. Counsel?
Good afternoon. I'm Sadie Ishii on behalf of Respondent MHLS. I'd like to just jump into the practical concerns that were raised by this panel, and I guess picking up where Judge Rivera left off.
Before you do that, just so we can get some sense of order on it, the standing issue is the argument that interested me, and we tortured opposing counsel on this issue, so I think that you should suffer the same
Fair
fate. My reading of your briefs is that you argue as an organizational plaintiff, but in point of fact, you're not a separate organization, are you? You're not a not-for-profit corporation?
That's correct. We're not a membership organization.
Because most of the case law that sets out what the standard is for standing for organizational plaintiffs involves not-for-profit corporations that come before the court. Novello, there's a number of cases that you've relied on and the other side has relied on. But that argument as an organizational plaintiff is, in my mind, somewhat irrelevant because you're actually a governmental agency. So what is it? Is your brief correct? Are you arguing as an organizational plaintiff, or are you arguing as a government agency?
So I think, Your Honor, that this question gets in a little bit to the differences between New York law and federal law. In the U.S. Supreme Court case of Hunt, there was a governmental organization, an Apple Growers Association, that was the organizational plaintiff in that case. And the Supreme Court said in that case that the basic test for organizational standing applies to non-membership organizations as well. They talked about something called indicia of membership. Now, it's my argument that there's no need for this court to import this separate indicia of membership test that the Second Circuit has recognized flowing out of the Hunt test. It's enough to look at the organizational standing test, which this court has
But you're not an organization. It seems to me that none of those tests apply.
So I don't see the need to have a separate test for non-organizational versus organizational, for non-membership versus membership organizations when you're talking about organizational standing. To the extent that this court does believe that a separate test is required, the First Department has...
The statute identifies you specifically. Isn't that the grounding for your standing?
Yes, Your Honor.
All right, but let me just go back then. If you say that's the basis, where do you say that in your brief? Where do you argue that?
So we argued extensively about individual standing, and the individual standing flows directly from...
But you're not suing on behalf of an individual. Where do you argue that, not an organizational argument, that you're actually, that you're a statutory authorized governmental entity who has a right to protect their particular obligations that were given you by the legislature?
We didn't argue it in that manner, Your Honor, but we did argue that as an entity that is named in the statute, we have standing individually to come in, that we are within the zone of
you are
interest,
the
we are a
individual.
beneficiary. I'm sorry?
So you are the individual as
Exactly.
opposed to the patient.
And then
Yes,
what-
exactly,
And then
Your
what
Honor.
is the injury to you?
The injury to MHLS is in the burdens to our staff from the lack of the records, the copy of the records being provided. And this really goes to the practical point that I was about to get to earlier about the practical realities of the situation where you have carts full of binders being wheeled into court. The record extensively documents how fluid these records are. Things are constantly being added in, pulled out of the records.
Going
and
back to
MHLS
Judge
attorney-
Stein's point, I think, you have access to all of that.
Yes.
So there may be some records on that cart, hypothetically, that you haven't seen,
Yeah.
right? Because you're saying it's fluid. But isn't that really an issue for a particular case? This case, these records are on the cart, or I make that motion. Here, we're speculating, maybe not, it's fluid. You have access to everything, unlike, I think, Judge Stein's concern, which is, what's the court relying on? Really, what's the specific injury here that hypothetically there may be something on the cart that you didn't have access to?
Your Honor, it's far from a hypothetical. This petition was commenced specifically because
Why wasn't
MHLS
it
started
commenced
noticing.
in that case? Why was it commenced by your organization?
In fact, Your Honor, it was commenced initially. The attorney who raised the issue said, I am raising
Raised it on behalf of your organization, as I
No, Your
recall.
Honor. The record documents that he initially raised it on behalf of all of the cases that were on the calendar on that particular day.
Okay, but
And then,
was any, and, you know, I realize that this is a pleading stage, really,
Yes.
but for standing purposes, injury has to be alleged particularly, and I couldn't find any particularized allegation as to any one of those cases and anything that was missing from the record that was brought in, or any injury to anybody as a result of something that was missing. So where is your allegation of particularized injury here?
so in the record on page 140, MHLS discusses the injury in fact as a result of the burdens on its attorneys in having to essentially not only review the record when it is on the unit, but then try at the last minute in the course of, 30 hearings on the calendar to compare what is there on the cart with what they knew to be there when it was on the unit 2 days earlier. And it's just a chaotic situation, Your Honor. And I would just point out here in terms of the fluidity of the record, these are records that at BPC in particular, any number of people are
So you
using.
don't allege that there has to be any harm to your clients as a result of this?
So for purposes of MHLS's standing as an entity that is harmed by the lack of a copy of records, we are not alleging that harm to our clients is required. I do think it does result in harm to our clients because they have a due process right, certainly, to disclosure of whatever evidence the state is relying on. And
Well, but it's not that it's not being disclosed, it's right there. Your argument is that they should have to pay to copy the entire thing, right? Even if it's not all going to be considered by the court.
Well, the state has said, BPC has said that it is offering these charts into evidence in every single 931 hearing. So these are, in
But
fact,
is
Do you ever
offered
object
into
to
evidence.
that? Have you ever objected?
Yes, of course.
I don't think that's, you can correct me if I'm wrong, because you guys have done more of these than I have, but what happens is the file is put in, the expert comes in, usually it's the doctor or the senior staff doctor or who's in charge of it. There's a file for a particular patient. You said that's marked in as a court exhibit. Then the doctor makes reference to it when giving testimony, but the file itself isn't put into evidence. So the evidence is the doctor's testimony based on the file, as in most medical cases. The whole thing isn't put into evidence because you'd have to redact 60 or 70% of that if you actually put that into evidence. Most of it couldn't go into evidence. So, and there would be no way for the court, and now we're talking the real world, there's no way in the real world that you can bring all that stuff there, have someone review all that stuff, and then mark it into evidence in the context of 30 retention hearings to be held on the morning in a Bronx hospital. It seems to me an impossible task for anyone to do that. The only thing that could be done is the records could be forwarded electronically if they were in evidence and the parties could share them, or they were required discovery. That seems to me a practical solution, but there's no way that they aren't used the way that counsel is characterizing them.
So, Your Honor, just to be clear, the record in this case does document that it is BPC's policy and practice to proffer the binders into evidence at every one of these hearings.
Right.
Not as a court exhibit,
Right,
but as
right. I
evidence
understand
in
that,
the case.
but let me ask you this. Is it your experience that it's done that way?
Yes.
Because my experience is they're not put into evidence. My experience is they're put in as a court exhibit, and that the expert testifies, and based on that expert's testimony in reference to a court exhibit, that's the proof that determines whether or not the standard is met to retain somebody or hold them over for night, whatever.
So, Your Honor, in my experience, yes, it is offered into evidence. It is often accepted into evidence. And I do think that as a practical matter, the legislature envisioned that both the court and MHLS would be provided with a copy of this record in advance so that to facilitate making the hearing.
So for example, because my experience is a little different down at Kirby and Manhattan Psychiatric, but so for example, the court, let's say the recommendation is to release, but the court looks through the file, the entire binder, and can then pull out portions of it and say, no, I'm going to retain because of what I've read here, here, and here.
Yes, Your Honor.
And it may not even be what the the expert is relying on.
Yes, Your Honor, and the place where that comes up most commonly is actually when a case is appealed, when the trial judge has granted release, and then on appeal, the appellate division acting as fact
exercising its own
finder is
fact-finding
looking at the
power,
entire.
yeah.
Right. So, as a practical matter, it really is critical that everybody be looking at the same evidence, that any time that one party is proffering something into evidence, that the other party have a copy of it, so everybody knows what they're talking about.
Just to be clear on the
Sure.
injury in fact,
Yes.
because I thought in part, I understand what you're arguing here, and
Yes.
I understood that. But I thought you were also arguing that there are these staff resources
Yes.
and money that are spent or would be spent if they don't make the copies, because you argue other facilities do this.
Yes.
So you don't expend your resources when you're dealing with those facilities.
Right.
This particular facility, you do have to. I thought that was part of the injury in
That's
fact.
exactly right, and that is referred to on page
Can you
140.
seek reimbursement from the court for those expenses of copying, if they were your obligation? And if so, how are you injured?
Your Honor, it's the expenditure of staff time and diversion of staff resources, although the monetary impact of having to make copies is a real thing, it is this diversion of staff.
Well, you may have an injury that's mitigated, but for standing purposes, you have been injured.
Correct.
Let me just, because I'm sorry if you've said this before, is BPC unique not having electronic documents?
In some
Is
respects,
this a widespread
yes.
problem?
So, yes, Your Honor, in some respects. You had earlier asked the Attorney General about electronic records. MHLS did a study which showed that 78% of hospitals statewide are currently using electronic records. We'd be happy to provide that information by letter to the court if this court would find that beneficial. In those hospitals...
Is it a public report?
No, it was internal, but I'm happy to provide it to the court if you need it. In those cases, it is virtually not an administrative problem because at the push of a button, you can have a copy of all of these records. Also under the CPLR, if you want to admit them into evidence, you certainly do need to push that button and have a copy present in court. Many of the hospitals provide them to MHLS via email, PDF, encoded PDF, et cetera. I know my time is up, but if...
Thank you, counsel. Counsel?
I want to begin by addressing call it the fluidity problem that Judge Stein was talking about, the changing nature of the record. It's precisely because because that is the system used in this statutory scheme, that the scheme is designed the way that it is. But ask the court to remember that this is a complete statutory scheme being construed, and the legislature did not intend the BPC to be limited from using events that have occurred right up to the moment of the hearing. The only way that you could have a fixed document that is frozen in time and given in advance would be to violate the statutory scheme and limit BPC from using records up to the moment of the hearing.
No, but you could have 98% of that record, and then you update it at the hearing. I don't think they're complaining about that. They would certainly understand that. They're talking about records that predate and then that you have time to make photocopies of.
And which they also have time to make photocopies of, and that's the way that the legislature intended it to work.
I understand your argument on that, but that's not what the statute says.
I disagree.
That's an argument you can make to the legislature, that it's overburdensome.
No,
That's not what the statute says.
I disagree. The legislature did intend the MHLS to do it. MHLS is an organization designed as a litigation entity, which BPC is not. BPC is represented by the Attorney General's office.
This gets into what is the record that we're talking about, because I should not assume, but I should ask you, would you agree that the statute requires the record as you've defined it to be provided, copied and provided to MHLS?
Of course, Judge Stein. Whatever record means, we have to turn over, the hospital has to turn over 5 days before the hearing. Nobody disputes that. This is a statutory construction case. And
so let me ask you this. The court's doing the hearing, and going back to, I think, the scenario I suggested earlier with your adversary, they don't, they want a reserve decision, as Judge Stein said, or there's an issue later on where there's an appeal because somebody's granted release and they want to go up on a stay to the appellate division. These things happen. They're the exception. And the court says, I need the record. Where do they get the record from? From you, right?
I don't know what is done in that particular...
When I say you, I mean BPC or the relevant hospital.
I don't know what is done in that particular circumstance. I know that what Judge Fahey was describing earlier is the way that I understand these proceedings to happen.
Well, there may be a difference
and there may be a difference. I would close by asking the court to remember that although it is our position that the legislature has designed a scheme that gives everyone the access they need at all times, and that was the intended form of access, the ultimate question before this court is only whether MHLS has, in a mandamus proceeding, met the burden of showing that record of a patient, that specific term as defined in MHL 9.01, that specific term must be read to include the patient's clinical chart. As I explained earlier, the regulation that they're relying upon to sort of make that intuitive leap from Article 9 to Article 33 and swap it in a different statute, it is an incorrect reading of the statute, but even if it were debatably correct, it is not clearly correct, and mandamus relief is not available. Any other issues should be resolved in a particular patient's case.
If we disagreed on the merits, standing and on the merits, is there anything that would prevent the commissioner from passing a regulation indicating that the clinical record is not part of accompanying data?
No, OMH absolutely could do that.
You could expressly have that kind of regulation.
It could expressly do that. And in fact, OMH is here today before this court affirmatively representing that it did not intend that regulation that MHLS is relying on to refer to Article 9. And we do not believe, given that there are no references to Article 9 in that regulation, that it should be read that way. But even if the court were to disagree with us on that, OMH could still solve the problem by simply adopting a new regulation that specifically defines the term accompanying data and therefore unwind that result, yes.
Thank you, counsel.